the property division, we made a mistake in the sense that we didn't include Rule 7 with our original filing. We did do a Rule 7 filing with regard to the reply. The issue with regard to the division is sort of twofold, and they somewhat are, I would have thought, interdependent, but they ended up being not interdependent. In the sense that Ms. Niemeyer was awarded at some point in time a gift in the year 2014. The interesting part about that is no gift tax return was filed until after the filing of a divorce, almost a year after the filing of a divorce for that gift. And so that property, there were two experts involved in this case, a gentleman named Matt Steltzman and a lady that was named Shannon Farr. Ms. Farr was Mr. Niemeyer's expert. Mr. Steltzman was Ms. Niemeyer's expert. Mr. Steltzman's worked for HHM, or Henderson Hutchinson McCullough, and by the way, Henderson being the other distinguished alum for Austin P last Saturday. And so Ms. Farr, who's a CPA, been a long time expert in the city of Chattanooga with regard to these types of cases. The judge found, upon hearing the testimony from both, that he found Ms. Farr more credible. Ms. Farr made a determination that the increase in the appreciation of value from the date of the gift until the date of the hearing was $444,000. Now, the judge found that, and he found that value at $444,000. What we take issue with is his determination that there was no, quote, substantial contribution, close quote, to the appreciation of those assets during the pendency of the divorce. And there are a number of facts that belie that. One of which is he actually signed as a guarantor on a loan that are related to those businesses being operated by the Pateras, which is in the record. He also worked there for 2 years. He also was at home with the children for 2 years when she was living in the same Bluffview area. They have an apartment. She was living in another apartment. But he had the 2 children overnight for those 2 years. He, to the extent, he was in school a lot, getting that PhD, but he did make some income, and he did contribute income to the family. He assisted with regard to the family in providing income. We take the position that that's a substantial contribution under the law. We cite you Ralston case that's in the brief that's almost strikingly similar in connection with that. So that's one issue in there. The other issue on the property division deals with his Alabama pension. He had a period of time where he worked for the University of Alabama, and he did end up with a retirement. In connection with the proceeding, Ms. Niemeyer requested that he be directed to go ahead and elect to receive that pension, which the judge ordered, and he did. In connection with that pension, the judge ultimately awarded the wife 40% of that pension. Again, not only do we have a separate property of $444,000 on the other side of the table, we're now taking 40% of the pension, which is not great. It's $3,000 probably a month, approximately. It's in the record. But he's, and again, they not only did that, they also, with regard to the child support in connection with this matter, There was an amount set with regard to that, and there was an arrearage that came out in connection with that, which my client had testified that he was willing to use his Alabama pension to support the children with regard to that. But again, judge made a different decision. He gave 40% to Miss Angela Niemeyer. He gave my client no percentage of that. She received all of her separate property, and she received most of the assets in the divorce that were there, which were, if you take out that 444 and if you address that pension, there wasn't much left, to say the least. This is a case that is a travesty. And I will just submit there is this man did not see his children during the pendency of this divorce. There were I filed 2 different motions for parenting time. They were never heard in connection with this matter until such time as in the year 2022. And again, in connection with this matter, you get sort of justice delayed is justice denied. If you never get a hearing on your case for involving your minor children, I would submit to you that's justice denied. And in connection with this matter, that's really sort of a moot point in one way, in the sense that the child is of majority now. But at the same time, I think this court should take a strong position with regard to the judiciary who get involved in these cases and who don't attend to making a determination by court order with regard to the parenting time. And it is one of the reasons that I put this in as an issue in the appeal. The other issue deals with the oldest child. When the original complaint was filed, there was no claim of severe disability. There was no claim for support. That was subsequently amended. There was a determination according to the plaintiff, by William Ray, that she was severely disabled. And one of the big issues in this case, as far as I'm concerned, is the deposition of Dr. Ray, who did not appear and did not testify, but is a clinical psychologist. And that makes him exempt for psychology reasons, but he was testifying as a vocational expert in connection with this matter. And he is not exempt from subpoena for being a vocational expert, and he should have appeared. And you will read, we read that deposition aloud in this transcript. There are objections every page. He had a report. The judge found that it was not admissible because I objected to it, but they read it during the deposition, and then they read it again during the judicial proceeding. And I'm out of time, and I apologize.
You have your rebuttal time left. Thank you.
I'm probably hitting a little direct still.
Ms. Bach.
Good afternoon. My name is Sandy Bond. I'm from the Hamilton County Bar, and I represent Angela Niemeyer. Good afternoon. I may have misheard what Mr. Konvalinka said, but my client, Ms. Niemeyer, was awarded 40% of that Alabama pension 2 years after her husband had begun to receive it. We didn't get anything back, but he got 60% of it. And I may have misheard what Mr. Konvalinka said, because it sounded to me like he said that he didn't get any of it, but he got 60 and she got 40. The separate property that he is discussing, during the trial, he took the position that he wanted no part of it. His proposed division of assets, his statements to the trial court. We want no part of her separate property. And they did not appeal the division of the pension. They only appealed and want a remand on the increase in value on her separate property. Now, how that property got so enlarged in 3 years is that Ms. Farr said that a debt that was owed to Dr. Portera on 2 of the non-income earning assets my client has, which she can't sell, there are restrictions on it. Ms. Farr said this debt that's been on the books for years that you are actually paying back to Dr. Portera. They're paying him and reducing it every year. She said, I'm going to change that. I'm going to say this is undercapitalized, so I'm going to take that debt and I'm going to make it a capital contribution. Well, she admitted on cross-exam that none of that money is there. It's just a line item change. And that's the only way there was an increase in my client's 1%, 2% overall of this business. So that's why I thought the Rule 7 was important, is because there are no assets in this marriage. There's the separate property, and I don't see how Mr. Niemeyer could contribute to an asset that went up because an accountant made an accounting change. And he didn't work for 2 years. He worked for 4 weeks when he was out of a job. With regard to the misuse of an order of protection, Judge Hollingsworth, who was not the trial judge, he heard the order of protection, and he found there was abuse, threats of abuse. And then Judge Bennett found that Mr. Niemeyer had anger management problems. And the record was replete with instances of his anger and shouting. At one point, they conceded because they said that this older child, the handicapped child, right from the beginning, Mr. Niemeyer was filing motions to require visitation with her. And so we went to mediation, and he agreed to pay child support for both children, and he wanted to go to therapy with both children. That only lasted till he took the job at the CDC. And then he never came back for therapy. So to say that the process robbed him of seeing the children is not quite accurate. There was a stipulation also in court by Mr. Niemeyer and counsel that it seems that therapy would be the only context under which he should see the children due to the outburst. There was testimony of a lady who worked under where the Niemeyers lived, and she said for years she heard the screaming and the yelling and the profanity, all aimed towards my client. And that was also testified to by 2 other witnesses in the case. The issue that we raised was the methodology of the 444. It was awarded to my client, and we have, it doesn't matter to us what she put on it. But now that he's come back and said, well, I said at trial I didn't want it, but now I want it. So now we have to contest that. In 2014, when she was given the property, and mind you, Mr. Niemeyer worked out of town from 1992 to 2015. He lived in Birmingham, Alabama. He was only home on the weekends. And when he came home, after having lost his job, he worked and did some leaf cleanup or something like that. But his own expert disputes anybody could have contributed to the increase because of the way she did it. He didn't keep those children for 2 years. And notice everybody calls them children. The oldest child is handicapped. Here's what Mr. Niemeyer said about his daughter. He said she can't live alone. She can't cross the street by herself. Can't cook. Can't ride a bicycle. Can't drive a car. Can't take a bus. He suggested that maybe she could work at the Goodwill shelter. he says her IQ is between 60 and 70. So even if you say that Dr. Ray, who did not read his report, is wrong and the witnesses are wrong, you just have to read what the father says. It's all right there. We think that we're entitled to attorney's fees. This case has gone on a very long time. It shouldn't have. It's just been debilitating for everyone. And we're asking the court to award our attorney's fees in this appeal, Your Honor. And I will say on a personal note, it's my last appearance before the court after 30 plus years, and it's been an honor and a privilege and a pleasure.
You're welcome. Thank you.
I'm sorry, do you have any questions? I'm so sorry.
I hear none. Thank you very much as well. Mr. Kavalinka?
So, just for the purpose of the record, I don't know that it's necessarily cited, but if you go to volume 18, page 885 of the transcript, lines 8 through 23. That's the deposition excerpt that I read into the record in connection with this matter of Ms. Niemeyer. And I ask, what basis, if any, do you have to deny Mr. Niemeyer residential time with his children? The response was, because I don't think they want it. I said, was there anything else upon which you base this basis? She said no. Now, what's happened in this trial, from day one, it has gotten worse with these children and with Ms. Niemeyer. Ms. Niemeyer ultimately testified in trial quite differently than she did in her own deposition. Scout, I mean, there's an exhibit in this file that you should look at. I don't have the exact difference, but it's in my brief, that has this man interacting with his minor child on a number of different sports and a number of different pictures. Again, there was obviously a relationship with this child, Scout, during this period of time. They have, quote, vilified this man during the process of this divorce in connection with this matter. With regard to the child that has been determined, quote, severely disabled, again, William Ray he gives you an IQ number without even doing an IQ test. My client is actually on a commission dealing with disabled persons. He testified about the child, and Ms. Bott didn't tell you the part that I heard about the child, that he said. She's capable of handling money, maintaining a job, maintaining personal hygiene, and capable of living independently. That's in the record. This statement that I stipulated to the therapy, take the site that she has in the brief. I think it's somewhat, she used numbers on the transcripts that were wrong, but they're in the transcript numbers, but there's different volumes that are the technical record. But in that, read that exchange, because she's giving you a snippet of the chain of the statement that's made. Because I'm before the court trying to get this man time, and you hear me tell the court, as if this is my only choice. Yes, he wants his time, so that we will do this. That is the reason that statement is made. There's not a, quote, stipulation. It is me saying, this is probably the only way I'm going to get it. This is exactly what I said. And so to suggest otherwise is just incorrect. I will also state with regard, this again taken out of context is my client's statement about the $444,000. All he wanted was his pension. He said he didn't care about having a portion of her 444. All he wanted was his entire pension. He didn't want his pension taken from him. But he did hire an expert who did make that valuation, and the judge did find that expert pretty credible in connection with this matter. Of course, he did not receive that pension. That's why I'm suggesting to you again, we're here with you before the court, asking you to remand this back for reconsideration of that division of equitable distribution of assets and liabilities. And we submit that it is well taken. I'm out of time.
Thank you, Mr. Complainant. I want to thank both you and Ms. Spock for your presentation. You should receive a copy of our judgment and opinion within a reasonable period of time. Thank you both. You may be excused. Ms. Spock, was you telling us that you're about ready to retire?